So, as I said, today we have three groups of audiences. One is the group of students from our university, bachelor's degree in law. Second group is students from European Humanities University, which is our partnering institution. We hope to have second double diploma with them. And the third group, a group of our students online and the faculty from our institution and the Department of Criminal Law and Procedure. Just a moment. Будь ласка, у кого звук трошки тихіше, тому що воно фонить. Sorry. So today, a lecture will be held by our visiting professor from Rikyo, Tokyo University, Professor Gregory Ashley. You can see him on the screen. He had a legal practice in Boston and New York, then he moved to Tokyo. Rikyo University is one of the oldest private universities in Japan. Basically, it was established by Anglican Americans in the 19th century, with the main building reminding me Harvard Law School. So this is one of the top universities in Japan and one of the top law schools in Japan. And his major is as you understand, in corporate law, corporate crimes, because he's advisor to corporations and students, and he also holds classes in legal English. As to myself, as to me, I'm a professor and a law doctor at the Department of Criminal Law and Procedure, Tau State Texas University. My major is criminology and criminal law, civil law, and I have interest also in constitutional law. So let's stick to business and start talking about our major topic of today. Basically, we'll discuss first crime itself and the elements of crime, the body of crime, or corpus delicti. Then we'll explain how important it is to prove the existence of the elements of crime during the criminal proceedings in the court, looking at a video episode, actually factual, not factual, but fictional criminal proceeding where both these elements of crime are being under investigation to prove non-guilty. And the second part will be quite interesting, corporate crimes and white-collar crimes. These crimes are interconnected. Some say, and this is true, that corporate crime is a sort of an offspring of the white-collar crime, but it's quite interesting because in terms of the mens rea, which normally should be the physical person, corporation is incorporated body. It's not physical, but still there is the vicious act committed by the corporation. And of course, there is certain common vision and common vicious behavior that results with a certain crime. So let's start with our topic. I hope that you'll be able to see the presentation. Let me check if you can see it. I will share it now. Just a moment. Okay, I think that you see the presentation, right? So the crime cannot exist by itself. It's not something which performs by itself. Normally, the crime is a vicious act and the act that results with certain damages. And of course, this vicious act, guilty act, cannot be committed by itself. It is committed by somehow. Here is a person with its vision, its vicious, guilty mind, and with its purpose. So in the crime itself, you can see the two elements which commit the corpus delicti, the body of a crime, One of them is in English actus reus, or criminally punishable act, or inaction, by the way. It could be also, or criminally punishable negligence. However, just the act itself is not enough for crime to exist. There should be the person, the vicious behavior. So in Latin, we say that actus non facit reum nisi mens sit rea, which means that an act doesn't make a man guilty unless his mind is also guilty. So only the two elements of a crime are enough for the person to be sentenced and to be charged with the criminal offense. Normally, and this is the practice of not just the civil law countries, but also this is the practice in the common law countries, that in criminal law, mens rea, or the guilty mind, or as we call it also, the vicious will, is a mental state of mind of a defendant who is accused of committing a crime. And in common law jurisdictions, most crimes require both proof of mens rea and actus reus, which is the guilty act, before the defendant can be found guilty. Basically, the same principle exists in the continental law. Also, all elements of a crime require proof for criminal offense to sustain. You might say sometimes a person who is charged with a criminal effect may actually make a confession. Is the confession enough to say that the person can be charged and sentenced for criminal offense? Well, coming to the origins, let's say in the 70s or 16th century, sometimes, of course, the person who is charged with a crime could make a confession. However, it's not always the case that this person makes a confession by goodwill. You know that many persons in the medieval times could be tortured, and actually, this sort of confession doesn't mean that the person actually did this crime. So, in the 17th century, it was Matthew Hale, the lawyer in England. He initiated the principle in court proceeding that this is only the court that should decide, where you can investigate all the elements of a crime to prove that there is actus reus and mens rea, and only in the court the person can be charged and be proved guilty. Confession itself doesn't make the person guilty. And since that time, basically, both in the common law countries like England and United States, as well as in the civil law countries, the continental European law like Ukraine, both elements should be proven in the court proceedings. And in both systems, in both families, it is true that there is a principle of confrontational clause, which means that accuser and accused person, suspect, have the right to see each other in the eye. This is a confrontation clause, which means that in the court proceeding, in the criminal proceeding, there is a questioning and examining of all the facts, documents, and witnesses of a crime. Both parts are balanced and equal in its right, the prosecution and the defendant. So, to say in simple words, the actus reus is the outward reflection of a crime, a conduct which must be proved against the defendant. It is that a certain event or state of affairs which is forbidden by the criminal law has been caused by his conduct. This is the act or inaction, criminally punishable inaction. Mens rea, or as we call it in Ukrainian, subjektivna storona zločinu, mens rea is the inward reflection of a crime, a state of mind, which he must be proved to have had at the time of the relevant conduct. It is that the conduct was accompanied by a prescribed state of mind. And both the prosecution and the defending party should prove in the court that either actus reus or the crime itself is existent, and there is a mens rea, or the vicious or guilty mind of a person. Normally, now we're talking about the physical person, but later we'll also figure out and see that sometimes the criminal punishment can be awarded also to non physical bodies, the incorporated bodies. But this is the second part of our lecture today. But let's see at the episode, this video episode from the famous movie, how the examining and questioning of the witnesses to prove that there is no actus reus, no criminal act, and there is no mens rea, no guilty mind, is actually taking place in the court proceeding. The movie, the episode is taken from actually the action. It's called Legally Blonde. Maybe some of you are familiar with this movie, maybe not. But I personally like this movie because it, in simple episode, shows the sophisticated issue of court proceeding, especially when the case is about the murder. The young lawyer from Harvard, Miss Woods, she's defending the lady who was coming back home to her husband, and actually in the house there was a daughter of this husband, and the man was shot with the gun, shot to death. And the daughter called the police that found the wife with the blood on her hands. However, there is no proof that she had a gun in her hands, that there are fingerprints on the gun, and actually, there is no still understandable reasons for her to murder her husband because they were a happy family. So now it's the aim and the purpose of a lawyer to check the witness, which is the daughter of the murdered father, to check the witness and question her and to examine facts and figures to check if there is a body of a crime, both elements of a crime. The first element, as I said, is actus reus, that should be proven in the court, and the second part is the mens rea.
Ms. Wood, you may begin your questioning.
Um, First of all, I would like to point out that not only is there no proof in this case, but there's a complete lack of mens rea, which by definition tells us that there can be no crime without a vicious will.
I am aware of the meaning of mens rea. What I'm unaware of is why you're giving me a vocabulary lesson when you should be questioning your witness.
Yes, Your Honor. Miss Wyndham, when you arrived back at the house, was your father there?
Not that I saw, but like I said, I went straight upstairs to take a shower.
And when you came downstairs, what happened?
I saw Brooke standing over his body, drenched in his blood.
I think that you don't see it on the screen.
Ms. Woods, you may begin your questioning.
First of all, I would like to point out that not only is there no proof in this case, but there's a complete lack of mens rea, which by definition tells us that there can be no crime without a vicious will.
I am aware of the meaning of mens rea. What I'm unaware of is why you're giving me a vocabulary lesson when you should be questioning your witness.
Yes, Your Honor. Miss Wyndham, when you arrived back at the house, was your father there?
Not that I saw, but like I said, I went straight upstairs to take a shower.
And when you came downstairs, what happened?
I saw Brooke standing over his body, drenched in his blood.
But Mrs. Wyndham didn't have a gun.
No, she'd stashed it by then.
Move to strike that from the record, Your Honor. It's speculation.
So stricken.
Miss Wyndham, did you hear a shot fired?
No, I was in the shower.
Okay. So, sometime in the 20 minutes that you were in the shower, your father was shot.
I guess.
Your father was shot while you were in the shower, but you didn't hear the shot because you were in the shower?
Yes. I was washing my hair.
Where's she going with this? Have a little faith, George.
Miss Wyndham, what had you done earlier that day?
I got up, got a latte, went to the gym, got a perm, and came home.
Where you got in the shower?
I believe the witness has made it clear that she was in the shower.
Yes, Your Honor. Miss Wyndham, had you ever gotten a perm before?
Yes.
How many would you say?
2 a year since I was 12. You do the math.
You know, a girl in my sorority, Tracy Marcinko, got a perm once. We all tried to talk her out of it. Curls weren't a good look for her. She didn't have your bone structure. But thankfully, that same day, she entered the Beta Delta Pi wet t-shirt contest where she was completely hosed down from head to toe.
Objection. Why is this relevant?
Oh, I have a point, I promise.
Then make it.
Yes, ma'am. Chutney, why is it that Tracy Marcinko's curls were ruined when she got hosed down?
Because they got wet?
Exactly. Because isn't it the first cardinal rule of perm maintenance that you're forbidden to wet your hair for at least 24 hours after getting a perm, at the risk of deactivating the ammonium thioglycolate?
Yes.
And wouldn't somebody who's had, say, 30 perms before in their life be well aware of this rule? And if, in fact, you weren't washing your hair, as I suspect you weren't because your curls are still intact, wouldn't you have heard the gunshot? And if, in fact, you had heard the gunshot, Brooke Wyndham wouldn't have had time to hide the gun before you got downstairs, which would mean that you would have had to have found Mrs. Wyndham with a gun in her hand to make your story plausible. Isn't that right?
She's my age. Did she tell you that? How would you feel if your father married someone who was your age?
You, however, had time to hide the gun, didn't you, Chutney? After you shot your father.
I didn't mean to shoot him. I thought it was you walking through the door.
Order, order. Order.
Oh my God.
Oh my God. Oh my God. Bailiff, take the witness into custody where she will be charged for the murder of Hayworth Wyndham. In the matter of the state versus Brooke Wyndham, this case is dismissed. Mrs. Wyndham, you're free to go.
Якщо в двох словах, я для наших колег перекладу ситуацію. Справа в тому, що під час судового слухання адвокат проводив, заслуховував свідка, який в процесі того, щоб перевірити, чи було дійсно вчинено злочин тією особою, яку звинувачують, а саме в її руках ніхто не бачив зброї, не було відбитків пальців, а також досліджувалася суб'єктивна сторона, тобто мотив. Але в процесі судового слухання свідок зізнався в тому, що він мав намір застрелити свою падчерицю, застрелити свою степ-мазер, як то кажуть, дружину свого батька, але вона не є дитиною цієї жінки, думаючи, що в двері заходить саме ця жінка. Тобто, фактично, довівши її до певного емоційного стану, було доведено в судовому слуханні, що нема ані об'єктивної складової. Yeah, that's no. Yes. Yes, I'm back with you. It looks like the microphone switched off because some technical interruption. I didn't do it. So in this criminal hearing, you can see that there is no actus reus or no mens rea. So actually, both elements of crime are missing. In the witness, during the questioning, actually being a certain emotional state, she, by accident, exposed herself by telling that it was her trying to kill her stepmother and shooting at the door when the father was coming in. She didn't expect father to come in into the house. She expected her stepmother to come in. So basically, during questioning on the witness and examining the elements of the crime, and it appeared to be that actually the person who was charged with the crime is not guilty. There is no actus reus, there is no mens rea, and the witness immediately turned into the person who became the suspect, and the previous suspect, the lady, was released from the court. So, but in this case, we're talking about the physical person. But there are cases when we are talking about corporate bodies. Corporate bodies are not the physical persons. These are entities. This is basically business. Gregory, do you see the presentation? There are some ambiguities in terms of the mens rea, in terms of a corporate crime. We're talking about corporate crime at the moment. Because we are focusing on the organization or a corporation as an offender that can create problems for criminal law. Because the corporation may not have an individual guilty mind. Also, it means that there is no classical mens rea. There is actus reus, but there is no mens rea, no state of mind for the crime, for there is no mind of the corporations. And this is quite an interesting case because collective mens rea is not formalized by criminal laws because, as you say, there is a principle nulla crimen sine lege. No law, no criminal punishment. However, there are countries, I would say, in common law and civil law, Netherlands and England, where corporations can be punishable under the criminal law. So there are some exclusions. And talking about basically other ambiguities, there are basically in the science opinions that where individual mens rea is desirable, corporate mens rea is not, because there is a greater emphasis on the sanctioning stage under the mens rea intent. So when we're talking about sanctioning side with reference to corporations, of course, collective sanction, both economic, non-economic, and punitive damages are possible with reference to the corporations, as well as we see it in the criminal punishment concerning the individual actions. However, when we're talking about the corporate crime, and it's also called organizational crime, which is committed within organizations incorporated for legal business, we shouldn't confuse it with organized crime because organized crime is centralized enterprises set up for the purpose of engaging in illegal activities who identify with crime and make crime their sole livelihood. So, corporate crime, talking about major definitions, is it includes crimes against capitalism. It could be corporate crime, which involves the crime of an executive in terms of corruption, for instance, who abuse the entrusted control and commit a crime against the business. So it's a crime against. However, in the focus of our interest are crimes not just against corporations, but white collar crimes where the executive works on behalf of the corporation and the corporation is involved into certain punishable action, the crime. Normally, we'll talk about it later in the section of Gregory, like ecocide and crimes by big corporations like British Petroleum. So, to say in simple words, white collar crime is a kind of crime which is generally determined by Sutherland, and this is the most popular definition. And this is a crime which is committed by a person of respectability and high social status in the course of occupation. Sometimes it's called the crime of the powerful. So the corporate crime is, as I said, it's an offspring, a type of white-collar crime committed by individuals within legitimate occupations, and it's made for the benefit of the corporate employers because an executive is also a stakeholder in the company. And usually such individuals, they don't believe themselves as criminals. On the other hand, I should also say that corporate crime is a multifaceted crime. It can include just general crimes. Of course, it starts from the white collar crimes, which is committed by an executive or the person who represents the corporation. And it also may include the conventional crimes because the instrument of this sort of crime can be bribe, fraud. It could involve ecocide and green crimes like massive pollution of air and water. It could also incorporate murder or even terrorist attack and smuggling. So now let's look at the cases themselves. What are the corporate crimes and how white collar crimes are involved in these cases? Gregory, the stage is yours now. Yes.